All right, folks, welcome back to the Property Couch podcast. And today's episode is a ripper. We are talking about a scenario where if you receive an inheritance, what is the tax impact of that? And folks, you might be surprised by some of the answers. Ben, what else do we cover?
Well, Bryce, if there's going to be a tax impact, how do we minimise that? So we're going to unpack a few ideas about how we minimise the tax on your estate.
Oh, I like minimising tax, Ben. Let's rip into the show.
Welcome to the Property Couch, where each week you get to listen to two of Australia's leading experts. Bryce Holdaway, co-host of Location Australia on Foxtel's Lifestyle channel, co-host of Escape from the City on the ABC, and partner of Empower Wealth Advisory. Ben Kingsley, chair of Property Investors Council of Australia and the founder of Empower Wealth Advisory, named the 2018 and 2019 Property Advisory Firm of the Year. Stay tuned as they bring you the insider's guide to property, finance and money management.
All right, folks, welcome back to the Property Couch podcast. And of course, welcome back to you too, mate. How are you?
Well, mate, I'm well, but there's only two things that are guaranteed in life, mate. Two things. Do you know what they are?
I wonder if you're going to go the two obvious ones or if Frio's going to get a bake here.
No, we'll go the two obvious ones. Go, have a go. What do you think?
Oh, mate, well, death and taxes.
Death and taxes. We're talking about death and taxes today. So here we go.
I like it, mate. I like it when you're up and about. We do have a very special guest today. We are talking about death and taxes. But, folks, before you go, pause and look for another podcast. Stick around. This stuff is important. It is going to cost you a lot of money if you don't work this stuff out. And we've done our very best to make this topic relevant and recent and captivating for you today. So, Ben, we do have a very special guest today. Her name is Julia Hartman. We will get to her shortly. But, hey, my Mindset Minute theme for today is, I think I've mentioned to you, I'm reading the Daily Stoic. Right, Ben? I've talked to you about the Daily Stoic. And this week's one was quite interesting, right? And it had a little story that went with it. So Seneca says this quote, right? The topic is when to stick and when to quit, right? So Seneca has this quote. Think of those who, not by fault of inconsistency, but by lack of effort, are too unstable to live as they wish, but only live as they have begun. Ooh. A little bit cryptic, so you got to let that sink, right? Yeah. So goes on in a bit more depth, Ben. In the Seth Godin wrote a book called In the Dip. And he drew an interesting analogy from three types of people you see in the line at the supermarket. This is where we land the plane, Ben. So just
got it. I'm with you. I'm hanging in there.
One of those three gets in a short line and sticks to it, no matter how slow it is, how much faster the others seem to be going. Stay in that lane, don't move, right? Then the second person changes lanes repeatedly based on whatever he thinks might save a few seconds, right? And then the third one switches only once when it's clear her line is delayed and there is a clear alternative, and then continues with her day. So he's urging, Seth Godin is urging you, which type are you? So Seneca is also advising us in that quote that was a little cryptic at the top end, to be this third type. So just because you've begun down one path doesn't mean you're committed to it forever, especially if that path turns out to be flawed or impeded. And at the same time, this is not an excuse to be flighty or incessantly non-committal, right? So it takes courage to decide to do things differently and make a change, as well as discipline and awareness to know that the notion of, but this looks even better, is a temptation that cannot be endlessly indulged either. So I was reflecting on this, Ben. I thought, I've actually done this. I went from brand new property personally as an investor, and I changed lines, and I went and I made a decisive change, and I went into established, and I've been established ever since. Also, I was in the project marketer line, Ben, and I thought it was the right line to be in. And then I made a change, and I went down to the buyer's agent path. So I thought this was super interesting, Ben, and maybe just to for our community who might have chosen a line, and if they resonate with the person who stays in that line and doesn't move. What about if you're the person that's in the line and you chase shiny objects? And I'm going crypto, I'm going art, I'm going property, I'm going to go development, all those sorts of things, versus the person in the third line. But I am susceptible, Ben, to changing lines like everyone, particularly in traffic.
Yes. I was thinking with some of my examples, like the ones that get me are obviously the lines that go through the security. And when you're going through immigration, I
Yeah,
always get in the slowest line.
yeah, yeah,
If I'm directed, I'm like, I really want to be over there. That one seems
yeah,
to be moving. And
yeah,
I get sent over into that one. But yeah,
yeah.
so no, I love productivity. I love trying. So I will move in lanes and do a few little
I think
things
you're
like
good
that.
at this. I think the summary is, folks, that be super determined and super vigilant on what you know until you get better information, and then if you get better
Yeah,
information, update and change
correct.
lines if it's clear that it's a strategic move for you to change lines.
One of the things I often talk about when I'm advising clients, Bryce, is, and I use the yacht analogy where, like if you keep tacking that yacht, you just don't build any momentum,
Mm.
right? So the longer you can, cut a lane and build up some of that momentum, but ultimately if there's no wind over there, you got to move, right? And you got to tack to get over into that wind. So I think there's something in the middle there that I really like about that wisdom. So thank you for sharing.
No problem. The Daily Stoic, if you want to check that out, folks, I'm really enjoying it. It's just little bite-sized little nuggets, Ben, just to give your little brain a little bit of food just to ponder the day. But let's get on to our very special guest today, Ben. It is Julia Hartman. She is a returning guest. You and I had a recent conversation with her. Let's cut to that chat right now. All right, Ben, we've got a very special guest on the podcast today. It is a returning guest. Her name is Julia Hartman. She is the founder of the BAN TACS Group, which is a national cooperative of tax accountants, which is a body of professionals who specialise in tax and property. And Julia is also the Chief Technical Tax Advisor for Empower Wealth Tax. Welcome back to the Property Couch, Julia.
Thank you for having me, Bryce. Good to be here. Hello, Ben.
Hello, Julia. Now, it's so great to have you on. We had Noel on last week, obviously with the new book, Wills, Deaths and Taxes, and we know that you were an important person in the collaboration you did on the tax chapters in this book. And so we're going to get to that as part of today's episode. I just think that this will be a really nice reference episode for people in our community over time. Where I wanted to start, Julia, was how often are you getting people asking you questions about inheritance, and then what does it mean? Because technically in Australia, we don't have a death tax, but there are certainly some considerations around that. So I want to set this up firstly by saying someone comes to you and they've inherited a house. So what are some of the considerations that person who's inheriting the house? So let's say it's my parents who have passed and I've inherited their home. What are the considerations that I need to be thinking about when it comes to inheritance?
Well, if you've inherited your parents' home and they were living there when they died, you're pretty safe as long as it's just held in their name. It's more a case of if you inherit something that might have been exposed to CGT in their lifetime that you've got to worry. So with your parents' home, even if you decide to keep it, Ben, it's their death resets the cost base to market value at that time, so you can keep your records from there, which makes it so much easier for you. Whereas finding what the BHP shares originally cost them and all that sort of stuff, or the rental property cost them, is where the problems lie.
Now, Julia, what if I decided, like, ultimately I've got a principal home. We live in Melbourne. My parents are in the bush, and I wanted to sell that property. What's the treatment there that I need to be thinking about? Do I have to sell that within, say, a 12-month period, or is there any other considerations that I need to look at?
Right, so it's the start, you've got the reset to market value at the date they died. You can then increase the cost base by anything you spend on the property after that date, including the holding costs. So, and if you sell within 2 years of their death, then you haven't got to worry about the capital gains tax consideration. But don't let that make you rush to sell within the 2 years, because you've still got that reset to market value. You're still increasing the cost base a bit. You're going to increase the cost base by the selling costs. So even though if you go out one day over the 2 years, you have to go back to the date of death, it still might not be that bad. There is also the ability to get an extension on that 2 years. You can automatically get an extension of 18 months, so you bring it up to 3.5 years. if there's something that was outside of your control that interfered with the selling of the property. And classic case of this of late is COVID, with people not being able to take people through the homes and stuff like that. But you're not going to get that extension if you've just held on to it speculatively.
So let's finish off this particular example on the principal home. I'm allowed to rent it out for those 2 years or 3 years and 8 months. That's correct?
3.5 years, but let's just say the 2 years, because the 3.5 years you've got to have this extra extension of time. And there is a little bit of a trick, which I think you're probably leading me into there, Ben, with the renting it out in that 2 years, is you get another reset to market value. So say you're getting up to, 20 months since date of death, and you think, oh, it's not going to sell. So you put a tenant in there and you get another reset to market value at that point in time. So that, especially if there's been a bit of a gain in there.
Beautiful.
Julia, I'm a degree qualified accountant. I spent a little bit of time in the Tax Act when I first graduated from uni, and whenever I read the books and wherever I read your blogs and have conversations with you, I feel like a numpty. That's the truth, right? Because it's so complex. When you think it's straightforward, it's not, and you. There's a couple of enemies that you talk about for sort of inheritance and executing of estates and all that sort of stuff. There's two enemies. You said one is fights between beneficiaries, number one, but number two, and it's a massive crusade that you're on, and that is the lack of record keeping. So can you give us sort of any case studies that you can think of where someone has been meticulous with record keeping and what difference that made for them, and someone who was just woeful in record keeping and what actually impacted us? Because what I'm trying to do is land the plane for the simple person like me and the listener who can relate, where it's like, why does this actually matter? I know record keeping probably matters, but how does that actually really matter when it counts?
Well, how are you going to know the cost base if you don't have the records? I mean, even you think, it's a pre-85 asset, so capital gains tax doesn't apply. How are you always going to prove it was a pre-85 asset if you haven't got the original purchase? It basically means, the bottom line is, if you don't have any records, you sold that asset for $100,000, you're going to pay tax on $100,000. Well, $50,000 after the discount. You don't have a cost base. And of course, the cost base in many cases can be increased by costs during the time you've held whatever the asset is. And remember, even if you inherit an asset and you gift it to someone, then that's a capital gains tax event at market value. So you might think, that's all right, this piece of jewellery. Some people say, well, how the tax office ever going to find out? I don't know. But this piece of jewellery, it's all right, we'll keep it in the family forever. And as long as people inherit it down the line, there's a rollover. But the minute you gift it to someone that didn't officially inherit it, that triggers a capital gains tax event on the value, basically, because you haven't got records.
I reckon that's a good one to lean in on, because a lot of people probably wouldn't think a lot. Like, the home makes sense, and record keeping is probably a bit forgiving for homeowners because they've got the registration of title. But it's those collectibles, those antiques, it's those keepsakes. They're the challenging one. I mean, I must admit, when I was reading through the book, it reminded me, yeah, that's true. I didn't think about that. That just the passing through, and as you say, gifting it to someone who wasn't intended beneficiary triggers a capital gains tax event. You don't. I'll speak for myself. I don't think about that so often, but you, as the custodian of the Tax Act, think about it a lot.
Yeah, I think one of the ways you get around that is to list it out in your will, who gets what. And most people say, don't worry, it's all the family. You divvy it up, love. And you've got to put it in the will.
Yeah. You threw a line just a second ago, it's not as easy with the BHP shares. I reckon that's worth leaning in a bit here too, because as I said, property, go registration, look at the title records. But to your point, what if you did get the BHP shares back in 1983 and and then you inherit them. And that is a significant piece of intel that you need to know, because if you are prior to 85 for that capital gains tax, it makes an enormous difference. So do you see many people get tripped up by that? I mean, do the share registries go back far enough for us to look, or does that get lost along the line as well?
Yeah, well, you might be all right with the BHP, but remember, they wouldn't have had their website with all the stuff back in 83. So you still, but then, if you know the date the person bought it, then you can know the value of the shares at that date, but you don't know the date. So you're going to have to go under their HIN number, and that could be hard, and no one wants to help you. But with the more obscure shares, a state mortgage was my nightmare. My mother-in-law had some. And they were taken over and taken over and taken over, and no one had any records. There was just nothing there. So you never know what's going to happen. And as I say to people, if you think this is hard enough for you to do and work it out and collect it and at least put it in a shoebox, preferably in my spreadsheet, but in a shoebox, then if you don't do that, how on earth do you think your heirs are going to collect this sort of data? And that gets them. They go, yeah, all right.
I think it's a really good point. I mean, let's sort of keep the spotlight on shares for a minute. If you've got a share reinvestment plan, there's obviously additional shares being added, and if you've got a stockbroker, or you're using an online share trading platform, if no one's got the passwords or the access, there's a lot of challenges around that. I know, like companies like CSL have done share splits. The value's got too high, so they're bringing the value back down. So it's putting all of that information together is time consuming. Now, of course, this is also happening during a period of grieving for the lost person that's been in play, and then starting to unpack all of their affairs as part of the will. And we know, in Noel's book, the number of people who don't actually have a will, which complicates it even further and extends that period of time on. So, Julia, with all of these nuances and different aspects associated with, sort of wills and deaths and taxes associated with that, what really surprised you the most that caught your eye in this sort of space?
Yeah, I learned a lot when I started digging into how things are treated when you inherit from overseas. And when you think about how many first-generation Australians we have here, it's a common thing now. And you think, all right, if they get the cash, that's okay, but they're not. It goes back to if you get the cash that the deceased had at their time of death, yes, that's all right. But and all the other assets, other than any assets the deceased owned in Australia, all the other assets are reset to cost base and market value at the date of death. But that could sit there, the estate could sell, say, a property in just after death, and a couple of years later pay the money to you. And you think that's all right, cash from the estate, I don't have to pay any tax on it. But because of Section 99B, because that's designed to catch income from overseas trusts, even though it was taxable, the whole sale event happened years earlier, but it happened after date of death, then that money comes to you as taxable income. And even though it's a capital gain, because it's been caught by 99B, you don't get to offset your losses that you've got in Australia. You don't get to get 50% discount on it or anything. And the simple solution in those circumstances may well have been, you've got to get the whole picture, like what the laws are in the country where your parents lived. But the simple solution may have been just transferring the asset to you first, and then you being the one to sell it. Then you've got the opportunity, not for all of the time, but for some of the time, to get a 50% discount. You get to offset your losses. That was a bit of a shock to me, and I'm embarrassed to say it, that I didn't realise that if they'd done it a couple of years back, that was caught too.
Ben, I think what's interesting here is, because you and I are getting to a certain age now where we're starting to think about, okay, we've got to set up our own estates. We've got our aging parents. We've had Jennifer Langton on recently. Then we've got this theme of sort of looking towards a time when we probably don't put enough thought into. But Julia, I think the overwhelming message that we want to give to our community, based on a theme of interviews we've been having over the last 6 to 8 weeks, is simple nuances, just like what you described. Accidentally doing it that way instead of doing it that way, when you have the choice to go right instead of going left, all comes down to having some quality advice up front, which could save you a lot of money. And I think for a lot of people, they'd just be wrestling with the idea of actual cash outlay now to get the advice for a future windfall. And I think that's the wrestle that a lot of people have. But I guess in your experience, you'd see it a lot, that when fast forward to estates being handed over, you can see there's large amounts of tax that could be given up, where you go, oh, if only I'd made the right decision back then, I'd have been fine. But it's that human nature piece that people have got to wrestle with now. Oh, do I spend the few thousand, or the couple of thousand, or maybe in some cases up to $10,000 to get it looked at now, to save myself scores of thousands in the future? So that'd probably be something you'd see a lot, where people have that, oh, if only I'd done this earlier.
Yeah, well, you think about how few people have even paid a solicitor to do a will for them. There'd be even less saying, oh, it must be pretty simple, because decades ago, before capital gains tax, it was, but now it's a messy business. So, yeah, their hesitance to pay for advice and get themselves sorted out is very low on their priority, even for a basic will, let alone a proper plan.
Do you have a framework when people come to you, Julia, and they say, I should look at my will, I should look at my estates? I know this is not your area of expertise, but do you have a general rule where you go, you fit this box, so you could probably do a simple will, whereas you probably fit this more complicated box, you need to go off to do a solicitor? Or do you just do catch-all, go to a solicitor and check it all out?
Well, I hate to keep on plugging the spreadsheet, but that's the first thing I do, is I say, what's your email address? I'll send you the spreadsheet, start
just
working
for the record,
on it.
the spreadsheet that you've got is outstanding. So we will definitely put a link for people who don't even know where to start to keep their records. Julia has put an enormous amount of effort into making that easy for you. So for our community, that'll be in the link. So the baseline is for your 101, Julia, is great record keeping. But what about beyond that? Let's assume someone is a good record keeper. Does that mean, okay, you're a good record keeper, go and get a simple will, or complexity, go and see a solicitor?
Always go and see a solicitor, and then I might give a few pointers about, depending on what they've got, about how the tax considerations here are. And I have some standard rules that I really dislike: testamentary trust, but if you want, there's ways around that to get all the benefits. And I hate life tenancies, because I've seen too many problems. So I give them a few horror stories in case the solicitor suggests testamentary trusts or life tenancies, because in the testamentary trust situation, I've had there's an income beneficiary of a $2 million trust, can't get anything out of Centrelink, and she's been asked by the trustee to live on $200 a week. She can't. So she's been made destitute by a generous trust, because the trustee is in control. You have it with life tenancies: who maintains the house, what if the life tenant needs to downsize, all sorts of things. And a huge capital gains tax event can happen, even if the remainder people, the people that will get the assets after the life tenant dies, even if they're trying to be good, they could trigger a capital gains tax event by handing over their rights so the property can be sold, depending on how the will is set up. And that's out of my league. That's a legal thing. But you're just opening a minefield. Whereas I say, if you didn't trust, if you want to provide for the person, surely you trust them enough to carry out your wishes in their will. You can do mutual wills. Or with the testamentary trust, if you're wanting to just give your grandkids an income stream that's not going to be taxed at the penalty rates that minors' income is, you just leave it to them direct. You don't need this testamentary trust set up. This estate that I was, testamentary trust I was talking about, where the woman's asked to live on $200 a week, the management fees are 25% of the income.
Wow. So they've been unlucky in terms of getting the trustee to be a little bit more generous in terms of the allocation. How old was the beneficiary?
The beneficiary's in her 60s. Yes, so she's got a long way.
Okay. Was it set up for a long period of time, Julia, that testamentary trust?
Well, it's for her life, but he only died a couple of years ago.
Okay. But she's in her 60s. That's quite interesting. I mean, from my experience in looking at the testamentary trust sort of structures, and again, I can't give advice here, but what I've observed is that if people have significant wealth, they have complex structures and multiple investments or businesses, there is some advantages for that type of cohort from what I've seen. But to the other point, and I think what's also important in the book that Noel's put together with your help is that there's the issues really are around blended families and siblings potentially contesting wills. What is very clear, through the courts is we're seeing more and more people contesting wills, especially in blended families and so forth. So that's why the documentation piece is so important. Do you from your point of view, Julia? I mean, look, I'll give you an example. In the book here, it talks about in superannuation, right? So it's not automatic that your superannuation forms part of your will. Like, and a lot of people may not have realised that. Like, ultimately, it comes back. Same with the testamentary trust. Inside super, there's a trustee, and ultimately the trustee makes the decision in terms of who ultimately gets the money. Now, there are means by which you can instruct and give direction in those types of allocations, but I think a lot of people would think that, well, I'm just going to say, and my super is as per my will, but it doesn't necessarily work like that. There's some paperwork and admin that you have to do. That's one of the interesting things I saw in there. And the other interesting thing that I learnt, Julia, inside here was that your super can't go to your siblings, so your brothers and sisters, and it can't go to your parents. Like that's quite unknown by most people.
Yeah, well, you can't make a binding death nomination other than down that line of your spouse or your dependents or your children. But that's why sometimes it has to be paid to the will, so it can be divvied up that way. So that's the two things people can do to try and avoid the will so that it can't be challenged is one, binding death nomination on their super, and the other one is a joint tenancy of certain assets. Because then the other person gets them by pure survivorship. So you can change that in a property. But also if they jointly own the shares with you, then that automatically goes to them and bypasses the will. So the trouble is that you trigger a capital gains tax event if you're going to change the title on anything now. So the family home, not a problem because there's no CGT property anyway. So you can make them joint tenants. But with the shares, there might be some capital gain in that time.
Is there a stamp duty trigger on a transfer also, Julia? A estate transfer?
Yeah, because you get the rollover only on the
CGT.
Debt, the rollover for the stamp duty too. You do. When it's inherited, you just change the name. But yes, if you were going to take, and there are different states have different concessions for family transfer. But yes, that's another cost of doing it. But it's probably a lot less than the legal fees of a challenge to your estate.
Yep.
Julia, what happens if we, the joint tenancy has the rule of survivorship applies? So let's say that husband and wife or partner and partner have a house and it's pre-85 and one of the partners survives and one passes in 2024. The rule of survivorship applies, so the other person gets that half, but that half is assumed to be owned post CGT. Is that right? Even though they both purchased it pre-CGT.
That's right. It's a common mistake. People go, oh, no, that doesn't matter. It was pre-85. And I go, well, how many names were on the deed when it was bought in pre-85? Yeah, so when you inherit the other half, it's a post-85 asset in your hands. You get a reset to market value for the cost base at the date of death on a pre-85 asset.
What does that mean? Let's land the plane for our audience. What does that actually mean?
So if you gave an example of the person dying in 24, so you look at the market value of that half of the house at 2024, and that would be your cost base.
Yeah.
And you start to keep records after that. But if you live in it from 2024 right through to your own death, well, then it's not a problem anyway. It's only if you decide to rent it out, then and not cover it with your
Ah.
main. So that's another trick. I don't know whether I should put this in here now, but you can continue to cover a place with your main residence exemption after you move out of it. And as long as you're technically covering it with your main residence exemption when you die, you still get this reset to market value when you die. So you'd be using the absent rule, the 6-year rule. You can rent it out for 6 years, move back in if you have to, reset it, and or if you've just got family living there but you've had to go into nursing care, well, then it's not earning any income at all. So you've got unlimited to continue to cover it with your main residence exemption. But that's how normally when it goes from dad half to mum, it doesn't normally trigger CGT because the normal family arrangements, well, mum's still living there when she dies. But otherwise, if it does become a rental property, or if it was a rental property, a pre-85 asset, you've got a problem. You've got a record keeping from the time they die.
Well, I think which comes back to, at the start of the show, we talked about the principal place of residence and time we've got to make a decision on the sale of that, but it resets the cost base. What happens on an existing investment property that the parents may have owned or that's being passed on to a sibling? What happens in that case where they're not in a relationship and it's being passed down to, my dad's just, I've inherited an investment property of my father. What's going on with the capital base there, Julia?
Right. Well, if that was a pre-85 asset to your father, then you do get the reset to market value. You even get the 2 years to sell, by the way.
Yep.
But if it's a post-85 asset, then you've got to go back to your father's cost base, and which is basically the price he originally paid for it, plus anything he can do to increase the cost base. So you step into his shoes, and that is where the problem begins. So the tax office, if you haven't kept the records, is a huge beneficiary of your estate because you could then go and sell it and say, I can't prove a thing. At least with a property, you can prove how much they originally paid for it.
Yeah.
But that's about it. Everything else, that the improvement, the reno they did, where's your receipts for that?
So, Julia, you're on a crusade to take money out of the tax office's pocket. Then that's what I'm hearing from you.
Just not pay too much tax. I think Bryce is that tax that you shouldn't have to pay.
Well, the record keeping helps with that.
Yeah.
The record keeping. Hey, Julia, I was interested to learn in the book that capital losses are lost on death. So first of all, what if the estate triggered a capital gain and there was a carried forward capital loss? They can't be netted at all?
No, but you've got to realise that capital loss. Some people hear that and they say, oh, these shares I've got have made a capital loss. I'm going to lose them on death. What am I going to do? And as long as you haven't sold them, you're not going to lose that capital loss on death because you haven't triggered it. So your estate will get to sell them and offset. It's only that if you've already sold the shares and you're carrying forward this capital loss, hoping that one day you'll be able to offset at a capital gain, that will be lost at death. So if you've got some profitable shares, sell them, offset that loss, and then your cost, buy them back if you want to. Can't do it as a wash sale. Maybe sell BHP and buy a similar mining company, Rio Tinto or something like that. And then, and even that, no. But I'm stretching it here. There is a law against wash sales. So,
anyway, we understand that. That's right, yeah.
So that seems cheeky. That seems really cheeky, Julia. Like if you've legitimately carrying forward a loss, and then on death it triggers a capital gain. That feels like it doesn't pass the fair test for the tax office. Like, it would feel like if they said after 2 years it's lost, but if it was just lost immediately and you can't settle it against the estate, that's cheeky.
And you wonder why I want to play it by the rules, but right up to because they get to make the rules and they really do take advantage. We've got to do everything we can to come up with that. But the idea is to offset the loss before you die by making a capital gain on something. And then that cash that you got from making that capital gain can be used to buy something else. And then you've got a nice new cost base. so that when your heirs inherit it, they inherit your cost base, but it's nice and high because they bought it just before death.
Yeah, but the problem is that no one knows the end date.
Yes, well,
Right.
I think, and most of us won't get to see that, but as you get older, it becomes more apparent. It's close enough.
And is it right to assume that cost base stays within that quarantine within shares or properties, or is it right across the board in terms of if you are resetting that, or the losses, are they quarantine inside share losses to offset against future share gains, or can it be across the board?
So if you're before you die and you sell off a caravan and make a loss on it, you can't use that loss at all. That's a personal use asset, unless you were using it to produce income. A whole new story. But usually, other than personal use assets and collectibles, any loss from shares can be offset from properties and all that sort of stuff. It's only those personal use assets and collectibles that quarantine. Yeah.
All right. Let's move on now to a case of where I might be inheriting units in a company, like a unit trust. So my dad has a passive investment in a business of which he owns 20% units of, and so I'm inheriting those units. What happens to my cost base on that particular inheritance?
Right. Well, that would be, so it's a unit trust. So he's paid some money to get those units, and that's all you're going to have. And of course, there might be more detail of that. There might have been returns of capital and stuff like that. But you're just standing in your father's shoes. But of course, then if your father owned those units before the 19th of September 1985, then there would be a reset to market value at the date of his death.
Got it. Thank you.
Ben touched on super before, Julia, but is there any difference for treatment, tax treatment post death, if someone was getting access to, super, whether it was in a self-managed super fund versus an industry fund? Is there any material differences, or are they the tax treatments treated the same?
Yeah, that's tax treatment's the same. The considerations are a bit different. You could be left with well, remember we said the trustee determines, if you haven't got a binding nomination, determines where the money goes. So if you've got one child as trustee, they might determine that they get all of it, mightn't they? So,
Funny that.
So but at least it's in the family then. If it's a super fund, at least it's controlled within that. The ultimate thing is that they cop the tax on if they're not a dependent, which is a spouse or a child under 18, then they're going to have to pay any tax on any taxable component that you have in super. But there is a little trick. Here's one. It's not even in the book, but here's a tip for you.
Oh, exclusive to the Property Couch.
Yeah. So if, say, for example, as parents get older, there is a good chance that one of the children will move in and help look after them, right? And then there becomes an interdependent relationship. The parents reliant on the child to look after them, and the child, who might not have anything, is reliant on the parent to provide them with a roof over their head. So interdependent relationship. There is a good chance that they could get that super out, even though they're an adult child, and it doesn't have to be a child, it could be anyone. They could get that super paid to them without having to pay any of that, what Noel calls the 17% death tax. They don't have to pay any top-up tax because they would be considered a dependent for that purpose.
Got you.
Nice little tip there. Now, I also noticed there was a couple of good examples on the super side in the book. And again, recommend you go out and have a read of it. It's a great little resource to start thinking about that, and then go off and get your advice from the right people, your tax people, your financial planners, and obviously your lawyers who do this. But I found an interesting story here around Simon, who had previously divorced from his first marriage, of which there were 3 children. And he'd since remarried to Yvonne, and she, at his death, she was basically the main beneficiary of his superannuation. Now, what happened here was the children of the previous marriage contested that. And so what was fascinating in the case study was this idea that whilst that was being contested, which carried on for a couple of years, is that estate was frozen. So the financial planner couldn't do anything, couldn't move any assets or anything like that. So there was no ability to continue to make money work hard for me. And then ultimately the story goes on to say that it was decided that Yvonne settled, before going to a lengthy court battle by issuing a third of the estate to the children. So that was a windfall for those children, which sounds like Simon wasn't really happy with that. These were all adult children who were very comfortable financially by themselves, but they went after some of the money. And then it follows on with a second case study talking about another couple who hear that story and then realise, well, how could they have prevented that? Well, how they could have prevented that was through having basically a defined obligation. What's the right terminology? It was binding nomination. Thank you. And so they went off and got themselves set up with a binding nomination. But in this particular case, this couple had two children and they were married for life. And these two children were very respectful of each other. And all of a sudden, by doing that, and the father dies suddenly and there's a $2 million estate, because they had this binding nomination, effectively that meant that there was a tax. There was $1 million given to Yvonne, and then the two kids got $500,000 each. But because of that binding nomination, there was a $170,000 tax liability that was generated by that $500,000. So in their case, the binding nomination wasn't a good outcome for them. So this is the nuance that we were sort of saying before about understanding what's in the book. What's your view on sort of stories like that, Julia?
Well, I'd like to add to the Simon and Yvonne situation and say, righto, so if Yvonne then goes and settles and says, I'll give you a third of the estate, so they go, righto, super fund trustee, you pay it all to Yvonne, and that's all right if Yvonne is the spouse. She'll get it all tax-free. It's a good outcome. But if it was two siblings arguing, adult children, then you say, well, Dad only left it to one sibling, and they say, it's all right, mate, I'll take it and I'll give you half, and so don't challenge it, leave it alone. Well, that sibling that takes it is going to be the one that's going to be taxed on all of it, the whole 17%, and then they give half. And one day they find out when they do their tax return, but meanwhile they've given half of it. They think they had a windfall.
Yeah, so that's where they're saying, look, let's just keep the administrative simple. It's come to me. I didn't expect that. I'm getting it. So let me, and then bang, a whack, a big, so what normally would happen in that case? Would they adjust for the tax payable and then deliver what's left over?
I've seen a situation where it was siblings and no, they didn't adjust. And the silly thing was they should have all agreed it went to the mother, and then there wouldn't have been any tax on it. But no, they all had to squabble. And yes, because it was sort of settled out of an agreement outside the court and no direction to the trustee or anything, basically, it was all paid to one of the children, adult children, and given to the other one.
Hey, Julie, my final question for you is tax returns. So what does tax returns look like post-death? How many typically get lodged if the estate has to be, settled over a number of tax years? What does it typically look like for final tax return being lodged and not having to be done again?
Oh, okay. So we've got the tax return that you've got to lodge up until the date of death.
Yep.
So you don't. You can include the accounting fees for doing that tax return in that return, but basically any income earned after the date of death goes in the estate tax return. So in that first year, you get two tax-free thresholds, one for the date of death return and one for the estate. And the estate continues to get that tax-free threshold for the next 2 years after the the death. So it's a total of
Yep.
3 tax returns, get the tax-free threshold. And you hope it's all sorted out by then. But you used to be able to get a letter from the ATO saying, we're finished, we're happy, you can distribute the last of it. We don't have that certainty now. It's not good.
And when you said before, when it gets extended for special circumstances, I take it that is a drag along. The tax return gets extended for those special circumstances too.
No, you can keep the estate going for years and years and years, but you're only going to get the first 3 tax returns where you get taxed as if the deceased was still alive, effectively, and all those step-up tax. Then after that, you either have to distribute it out to the beneficiaries so they get taxed on it, or you get taxed as in the hands of the estate. And you could maybe even get as low as 19 cents in the dollar tax bracket, the ATO's discretion, but it can go as high as 47 cents too. So, you want to tidy it up. Well, everyone wants to tidy it up pretty reasonably because it just costs you money to run these things. Another example, I've got a young girl she's not a young girl anymore, but her mother died early and the money was put in trust for her. And by the time she turned 18 and got it, there was no more money than what was originally there. Every cent of income it had earned, and it was very conservatively invested. It all gone out in fees. So.
Julia, just on that point, and I remember what you were saying about the fees going out at 25% from a trustee, a professional trustee managing that. Can you lobby to move from trustee to trustee where you might get a cheaper outcome for the management of that, or is that not possible? The trustee has all of that control.
Well, that's what the will says. It specifically put them in charge. So it's going to be, we might have to get a solicitor to try and challenge that. We're getting a barrister's opinion at the moment as to how on earth we get this trustee removed.
Yeah, especially if they're charging 25% and only giving the client $200. That's ridiculous. Yeah, not good at all.
Yeah, and I mean, it's more income than just the $200 or whatever. It's just they're saying, oh, no, we've got to retain it. And one day in your old age, you might need more money, so we'll keep this here just in case. And, we've got to provide for this and we've got to provide for that. And, of course, they get 25% of the earnings on what they're retaining. So you put the mouse in charge of the cheese.
Yes. I think that's a bit greedy. That's very greedy indeed. So, Julia, my last question brings us back to the housing. We're property people. So let's talk about the, sort of a scenario where maybe my cost base may not necessarily be reset. What's the scenario where that might happen?
Well, if it's not covered by your main residence exemption, when you completely covered by your main residence exemption when you die, you don't get that reset. So you don't get, if you happen to be renting out a room when you die, you're not going to get the reset. It all has to be calculated as to what's covered by your main residence exemption. But also, if you own the property as joint tenants, you don't get a reset to market value when you inherit the other person's share. You still have to have considered to have held it the same way they held it. So that reset doesn't happen. So sometimes it is worth considering buying it as tenants, not buying it, but even changing it to tenants in common. And this isn't a stamp duty cost because if you owned it equally as joint tenants and you change it to tenants in common 50-50 ownership, then there's no change of ownership technically, just the way you hold it as tenants in common. Then that goes to your estate. So it's inherited, but it goes to the estate with all the problems associated with being challenged, but it goes to the estate and it's inherited. Therefore, it gets the market value reset to date of death. Now, this could be very relevant if you've rented the house that you're living in now out way back when you first bought it, then all that time there's going to be a capital gains tax event if you sell it. Now, if instead you're living in it when you die, that's overridden and it's inherited at market value at date of death. So all that's forgiven and forgotten. But it's got to be inherited. So if the other person gets it as survivor because of joint tenancy, they don't inherit it. So they've still got to pay that capital gains tax when they sell it. So all for the simple thing of switching from joint tenancy to tenants in common, they doubled their tax bill, or they can halve their tax bill by doing that because they've still got the exposure on their half, but the half they inherit then doesn't have that capital gains tax exposure.
So if I can summarise that, if for any reason you've let out a bedroom or you've had it as an investment property for a period of time, that is the trigger event to go and speak to your accountant and the lawyer about how you might adjust the way in which the ownership is structured prior to death. Because I was sort of thinking then, if I'm the surviving spouse, I'm going to inherit that anyway. And if it's a clean asset as a principal place of residence, then ultimately once I die, that capital reset value will then be passed on to my kids. So there's nothing to see here. But it's really when you've got a bit of a checkered history in terms of the purpose of use of that property up until that time. So it's a nice little bit of advice there, Julia. And that's why we believe that you're the number one property tax lawyer in this country, and that's why you're our chief tax officer here at Empower Wealth as well. So thank you very, very much for coming on today's show. And of course, we're going to plug the book. We're also going to plug the worksheet that you put together, where the record keeping is really important, because Bryce and I's message is really simple here. This is complex stuff. There are nuances. There are, lending and basic property selection, compared to what we're talking about here. It gets very, very technical with all of these legal definitions, terminologies, and treatments. And in some cases, it's wise to go down a certain path and unwise in other cases. And that's why for every household, it is unique. Your situation is unique. Your backstory on the assets that you own are unique. And so we would highly encourage you to record keep everything. Keep communication going with your loved ones about what your intentions are. Have a will in place. Regularly check up on that will. And then you're going to see, even though you might be passed, you don't want to leave a baggage of mess behind you. So please get that advice. It really, really is important. And to Bryce's point earlier in the show, we're at an age where our parents are getting older. We've got to start thinking about this. We've also got to start thinking about our own estates in terms of how we organise those. So it's timely for us to be asking lots of these questions, and we're on a learning journey here as well. So thank you very much, Julia, for coming on and giving us more of that education. And if anyone has any questions around this, please feel free to reach out to us through our socials or through the Property Couch and give us some of those questions, because we want to continue to keep educating here, because there's an enormous amount of generational wealth transfer that is going to occur over the course of the next decade or so. And so it really is important that you think about your estate planning and also the tax implications of those. We don't want to give the tax office any more than they deserve as part of that journey. So thanks again, Julia, for coming on the show.
Thank you for having me, guys. It's been good.
It's always a pleasure. Thank you, Julia. There you go, Ben. Complex stuff. Like, I was not lying at the top of that interview when I said I do feel like a numpty. I feel like I'm reasonably well-rounded at this stuff, and then I just get caught in the little rabbit warrens that you go down, and like my mind starts boggling, and then you go, gosh, if you don't take the time to get strategically correct about this can cost you a lot of frustration, time, energy before you even get to the fact it's going to cost you money.
I agree. I mean, I summarise it like this. If I've got blended family experiences, then my paperwork needs to be elite. I need to make sure I'm all over it. If I've got a simple situation where, my asset base and my estate base is pretty simple, then get a simple will done. You don't need all the fancy bells and whistles. As the complexity in your life and the complexity in your wealth position and all that grows, that's when potentially you're moving up the ranks in terms of who you seek your advice from. And that served me pretty well on my journey in terms of the advice that I've got and how I've structured my estates beyond my death as well. So it really, we try and keep it light for this show. I know that people are going to have to rewind certain sections to listening, but here's another little bonus thing for those people who've hung around at the end here, Bryce, and that is we have another little handout that we put together. It's called Death, Capital Gains, or GST, Your and Your Home. So it's very property specific, but it's a great little handout that complements the show really well. So it's going to be a nice little reference guide for you, and it's obviously going to be a starting point for which you can then make your journey into wills, deaths, and taxes in terms of how you do that. And obviously we recommend Noel's book for that particular story. So check it out in the show description. You can get access to that link. It's going to be really helpful for you. You've heard us in my last question there, a little bit of a nuance in that area. And we started the show talking about property and its relationship with inheritance. And that's going to be outside of super, potentially is going to be the biggest inheritance that is going to be passed on to the next generations. So you want to get it right. You want to get your property story right with your kids or whoever's going to be the beneficiary of your estate. So download that fact sheet now because you'll love it. There's lots of great information in there. And we thank Julia deeply for her rich knowledge in terms of putting that fact sheet together for us.
Yes, that's true, Ben. And I think you mentioned it in the interview that we just had with Julia as well, that we are going to go through the greatest wealth transfer through generations that we've experienced, given the baby boomers are such a large population group. It's happening for the first time. So that's why we're putting this stuff on the radar for folks right now. It serves a conversation point that you and I are having off camera with our parent. But two, it just gets people starting to think about certain things that they should be thinking about. So, and a special shout out to Julia, just so everyone knows, Julia loves for us to queue up very clearly what we're going to talk about before we do. And you and I are more of the, can we just have we call it the fireside chat. Can we just have a little fireside chat and see where the conversation goes? And so she sort of went, okay, no problem. And so she did incredibly well.
She nailed it. We were still a bit stumbly there with some of our questions.
Thank you, Julia. We appreciate you doing that.
And Bryce, just before you move on, don't forget to also have a look at the record-keeping spreadsheet that Julia's put together. It's also in the fact sheet, and there's a link there as well as in the show description as well. So thank you for that.
Oh, very good. Well done, Ben. So my life hack today, Ben, is a very practical one. I want you to picture this, Ben. You're putting on a pan of pasta for the kids, all right? You've got it on the stove. Then all of a sudden, Collingwood kicks a goal, Ben, and you just get distracted. And before you know it, you turn around and the water is just overflowing and it's bubbling over the top of the pan and it's all going all over your pots, right? Well, I've got a little life hack for that, Ben, that I learned.
Okay.
What you do is you get paper towel, and then you put some olive oil on the paper towel, Ben. And what you do is you wipe the olive oil around the top of the pot, right? And then what happens is the bubbling water starts to bubble up. But because of the viscosity, is that the right word, of the oil, the bubbles don't get to bubble over the top, Ben. So they just keep bubbling up. So those who are watching YouTube, Stiggy will put that in a little image of what that looks like. But just a little bit of oil around the outside.
Around the edge, and it doesn't quite get through that barrier.
It's like trying to jump out of the pan, but doesn't get there, right? And
I got it.
So then you can go and watch Collingwood get that, rare goal, Ben, and just not have to worry about stuffing up the pasta.
Just get the W. Come back to the pasta. It'll be a bit dry later on. It won't be al dente. It won't be al dente, but
doesn't matter. The boys will be the boys' soul will be fed because Collingwood had another win because it wasn't grand final day, Ben. So they have a very high likelihood of winning if it's not grand final day.
And no stove to clean up afterwards. That's right. Great result.
So that's my life hack this week, Ben. But before we go, you've got something to announce?
Well, Bryce, of course, it's tax season now. So if you haven't got a investment savvy tax accountant and you want someone to look after your tax affairs with your investment properties, of course, I'm putting our little hat on at Empower Wealth and saying, if you do want to talk to someone about your tax affairs in relation to your investment properties or your personal tax matters, we would be delighted to serve you. So if you want to learn more about that, just head to the Empower Wealth website and you can book a free appointment with us to have a conversation with our team to look after your taxes.
Well said, Ben. And we're going to put a little link on the screen here. It's thepropertycouch.com.au/tax. That'll get you there, Ben. Nice and easy. But I reckon today's episode has shown the reason why it's good to get someone who specialises in tax, because there's so much tax act that people have to be across, and the little nuances in each of the acts is super
agreed.
So,
agreed.
Thepropertycouch.com.au/tax. We would love to help you out, as Ben said. But mate, good show. Lots of information we packed in that. But until next week, mate.
Knowledge is empowering, but only if you act on it.
See you next week, folks.